Hedayat Matin Daftari as the next witness. Mr. President, before I begin with the examination, I wish just as a scheduling matter to explain that the lunch break was to have been at 12:40. I don't assume that we will go considerably over that time period, but I beg your indulgence if we are perhaps 10 minutes or so over that time period.
See how it develops, but you will have extra time if it's necessary to conclude.
Thank you, Mr. President. Good morning, Dr. Matin Daftari. Could you please introduce yourself to the court?
Well, I am Matin Daftari, as it was mentioned, and I'm a vice president. I was a vice president of the Iranian Bar Council, which has since lost all its independence, and that's why I'm here, and I'm in Europe as a political refugee, and I've practiced law in Iran before I left for Europe as a political asylum seeker, and my studies are in law, and I was educated at Cambridge and Tehran University. That's about all I can tell you.
Thank you. So just to be clear, you were the vice president of the Iranian Bar Council in which years until you were forced to flee Iran?
The election, the last proper election of the Bar Council of the Iranian Bar Association took place in 1978, in the spring of 1978. And I was the top winner of the election, meaning I had the most number of votes from my colleagues. And the bar elected me as the vice president. We had two vice presidents, one president, and we worked together in equal levels.
And until which year? When did you leave Iran, which meant that you were no longer able to serve that function as vice president? In which year?
I left Iran in 1981, in the autumn of 1981, to be precise, the month of November, to come to Europe.
So it would be fair to say that you were active in the Iranian legal community in the very first months of the Islamic Revolution in 1979.
I was, until I was forced into hiding in the more or less at the beginning of September or end of August of 1979 for my protests and arrangements for reporting the human rights abuses of the newly established regime.
Thank you. Now, may I turn your attention to your document in the judge's bundle, which appears as the second witness statement, beginning at page 5. Your statement is in two parts. It is a rather lengthy statement of 26 pages, and it is entitled Penal Policy in the Islamic Republic, Instruments of Flagrant Abuse of Human Rights. Is that statement an accurate and truthful reflection of your views about the Iranian legal system? based on your experience and expertise.
Absolutely.
Thank you. Now, could you perhaps explain to the court the fundamental basis in the Iranian constitution, and by extension in Iran's penal laws, of the so-called velayat faqih, the rule by the Islamic jurist? Your statement describes the basis in Sharia law for Iran's penal legislation and the respective authority of the Supreme Leader Ayatollah Khomeini. Could you briefly explain to the court what the basis of that authority was and what implications it had practically on Iran's penal legislation?
Well, in the new constitution, which was established by the new regime in Iran, the legal system has been based on fiqh, which is Islamic jurisprudence, and not, a special section of the Islamic jurisprudence, which is the Ja'fari section, or the Shia section of the Islamic jurisprudence, as interpreted by the faqihs or the people like Ayatollah Khomeini, who was at the time established under the Article 5 or Principle number 5 of this constitution as the representative of the hidden imam, and therefore as the supreme jurisprudent, a position which puts him above the law and above the constitution. And this very same constitution, in its principle number 2, it holds that the law of the land and the practice will be the practices of the jurisprudence of this particular school. And in some respect, when we look back at what happened at the time, they came forward with two points in their mind. One, to destroy the existing penal policy, the existing penal code, and the existing judiciary, and replace it with a Islamic Sharia judiciary, and bring forward a constitutional law or a constitution which would uphold this. And one of the first attempts at this was, before actually having a constitution, they started a parallel type of judiciary presided by Sharia judges, and working extrajudiciary outside the existing judiciary, because the constitution did not come into force until late in until the autumn of the 1979. And during that time, you had the Islamic revolutionary courts, which were in charge of the affairs, and the actual judiciary had become a sort of a fifth wheel in the organization of the country.
Thank you. Turning to your statement at paragraphs 3 to 6, you identify 3 steps in this transitional period where you were the vice president of the Iranian Bar Council. You explained first that Islamic revolutionary courts were established. Secondly, that a constitution gave absolute sovereign powers to the supreme leader. And thirdly, that in 1982, Ayatollah Khomeini issued a fatwa declaring that all laws that contradicted the Sharia, based on his interpretation, would be null and void. Is that correct?
That is correct.
Yes. Now, I would like to address some of the specific crimes under the Sharia law to which you refer in your statement. Firstly, you mention in paragraph 6D of your statement that under Article 167 of the Constitution, alleged perpetrators were not required to have legal notice of the existence of their crimes under the law. So what we call the principle of legality, nulla poena sine lege, the requirement that there be no vague or retroactive criminal laws. Was that principle respected in the Constitution of the Islamic Republic?
Not at all, in many respects, not at all.
Thank you. Now, you refer to a number of different crimes, and I would like to ask you to elaborate somewhat on those. These explain the crimes of muharrebe, mufsid fil arz, muharrebe being waging war against God, mufsid fil arz, which refers to the corrupt on earth. Could you perhaps explain to the tribunal the definition of those crimes and how those crimes were in practice applied by the revolutionary courts?
Muharebe does have some sort of description in the actual penal code, which is the Islamic punishment, the law of Islamic punishment. And it means it includes, but not limits, crimes to people taking up arms against the actual order, existing order. But ifsad fil arz or corruption on earth does not have any understandable actual definition in the law. The definition is left to the judges to decide. And in this very same law, it allows collective condemnation of people, because it says that if an organization, if an organized force is made which has taken up arms against the existing order, all people connected to it, all people who have associations with it, all members who do not have anything to do with the actual armed struggle, and those who any supporters or any associates, they would all be held responsible for the crimes of the organization. And this was later on, as I have mentioned in this document, which I've prepared, and more elaborated by Ayatollah Khomeini himself. And one good example is the fatwa, or in fact it wasn't a fatwa, because fatwa is a sort of legal opinion by an Islamic jurist. What was issued by Ayatollah Khomeini was a judgment and a command against Salman Rushdie. But in this command against Salman Rushdie, he mentions that all those people associated with the work of Salman Rushdie, they are also his allies, and they should also be punished in the same way as it's prescribed for Mr. Rushdie himself. This was elaborated by the chief justices in Iran, saying that Ayatollah Khomeini has made things very easy for us, because we do not have to investigate every person one by one. There is collective judgment, and once we know a person is connected with a certain type of affair, then we will be able to execute him within less than a week, rather than going through investigation on the actual individual and establishing the actual individual's act of crime in the country.
Thank you. At paragraph 43 of your statement, you refer to a statement by the head of the judiciary, Mr. Muhammad Yazdi, who makes a statement to the effect that sentences announced by His Holiness the Imam, referring to Ayatollah Khomeini, against persons such as the sentence of apostasy pronounced against Salman Rushdie, were not simple fatwas or expressions of religious opinion, but sentences of death, which include proper directives for the executioner. He goes on to explain that in relation to groups such as nationalists, liberals, the Hujjati Society, and the Nehzat Azadi, or the Freedom Movement, which he explains is written in the handwriting of Ayatollah Khomeini, and he refers there as well to the judicial sentence for the Munafiqeen, the hypocrites, which refers to the People's Mujahideen organization. Mr. Yazdi explains that the fatwa issued by Ayatollah Khomeini against those groups means that he has condemned the organization, its organs, and its members in their totality, collectively, and not individuals separately. So just to clarify, this means that any individual which belonged in groups that were covered by those fatwas could be executed without any further inquiry as to whether they have in fact violated particular laws or not. Is that correct?
That is correct.
Thank you. Now, I'd like to take you quickly to a few other concepts of Islamic law which are of relevance to the testimony that this tribunal will hear. In particular, I would like to address the concept at paragraph 53, subparagraph C of your statement. I'm terribly sorry, I have the paragraph wrong here. I was just going to find the relevant quotation. Here it is, I'm sorry, it's paragraph 15 of your statement. You explain that the use of torture to extract information or confession is forbidden by Article 38 of the Constitution of the Islamic Republic of Iran, but that there is a notable exception in the form of ta'zir punishments. Could you explain what that exception to torture is according to this concept of Sharia law, and how it was used in order to extract confessions from defendants or prisoners?
Well, I have to first state that what ta'zir is. I mean, there are in the jurisprudence that is practiced and upon which the law of Islamic punishment is based. There are 4 sections. The first section is the had, or the rights of God, and the punishments for which are actually established, and the Sharia judge cannot change them, except for the punishments for muharib, meaning warrior against God, and mufsid, corrupt on earth. 4 types of punishments are prescribed. One being death, another one being crucifixion, another one being the mutilation of the right hand and the left foot, and the third being banishment, which they have interpreted as being imprisonment of not less than 1 year, pending the repentance accepted by the Sharia judge by the prisoner, which this could extend to many, many years of imprisonment. As I have recently also seen, a mother of a person who went to visit him amongst the Mujahideen, she was arrested in Tehran, and she was given 10 years of tab'id, 10 years of banishment for having gone and shown associations with the Mujahideen. I mean, I'm terribly sorry, I'm deviating from your question. Is it all right?
Yes, yes. Perhaps I can go on to consistent with what you're saying, to turn your attention to the fatwa issued by Ayatollah Khomeini in 1988. It appears at page 67 of the Commission's report. I believe you should have a copy on the table, and I'm sure you're familiar with that fatwa.
Yes.
And at page 67 and 68, you will see a copy of the original Persian text and the English translation. Now, consistent with what you've said about the various Sharia concepts with respect to crimes which can result in execution, we see here in the English translation, in the name of God, the benevolent and the merciful, this is the fatwa of Ayatollah Khomeini. Since the treacherous munafiqeen, which was one of the concepts that you refer to, do not believe in Islam, and whatever they say is stemmed from their deception and hypocrisy, and since, according to the claims of their leaders, they have become apostates of Islam, and since they wage war on God, once again the concept of muharrib, which you've referred to, and the fatwa goes on to make a number of allegations of espionage and armed struggle, before concluding that it follows that those who remain steadfast in their position of hypocrisy in prisons, hypocrisy once again referring to the notion of munafiq, are considered to be muharib and are thus condemned to a sentence of death. Is this fatwa an example of the phenomena that you are speaking of using very vague general categories of crimes to impose collective sentences of death on political dissidents?
That's it, exactly, yes.
Thank you. Now, I would like to take you to paragraph 20 of your statement, where you speak about how the Sharia law, as interpreted and applied by the Islamic Republic's constitution, did not treat Muslims and non-Muslims equally. Your statement says, and I quote, "If a Muslim kills a non-Muslim from a recognized religion, no retribution is permitted unless the murderer makes a habit of the crime." Could you please explain to the tribunal what you mean by that, the fact that there's no retribution unless the Muslim makes it a habit to kill other non-Muslims?
Well, if the killer, in fact, keeps on killing the non-Muslims, I mean, he starts a massacre or a serial killing or concepts like that.
But a single murder then would not be punishable under the Sharia?
No, it will only have a DA. I mean, I was explaining the 4 different parts of the
blood money,
Islamic punishment, the blood money, DA, and it'll be about 1/10 of the DA of a Muslim.
Thank you.
The blood money of the Muslim.
Thank you. Now, just to go one step further, you specify in your statement that if a Muslim kills a non-Muslim from a recognized religion, are you referring to Article 13 of the Constitution of the Islamic Republic, which specifies which religious minorities are recognized?
Absolutely.
So if a religious minority does not feature in the list of protected minorities under Article 13, and I refer here in particular to the case of the Baha'i minority, which was not a recognized religion, declared a heresy, what would be the legal consequences of a Muslim killing a Baha'i or other member of a non-recognized religious group?
None whatsoever.
So would it be fair to say
there will not be any blood money, there will not be any retribution, there will not be any punishment at all?
So it would be fair to say that those that are not protected religious minorities are without the protection of the law?
They are not protected, no.
Thank you. Now, I would like to move on from the question of the Sharia law, the sources of Sharia law, its interpretation, its application, to discuss the revolutionary courts and their composition. You explain that, certainly during the time that you were Vice President of the Bar Council and subsequently based on your research, that the existing judicial system as it existed during the government of the Shah was dismantled and replaced by revolutionary courts. Could you tell the tribunal something about the qualification of judges on the revolutionary courts and the degree to which they exercise those functions in an independent or impartial manner in applying the Sharia law?
First, before I mention that, I have to tell you that one of the first tasks of building the Islamic judiciary was to, in fact, purge all the existing judges who were trained lawyers and who had law degrees and who were trained as modern judges in the modern judiciary that existed in Iran, which was developed from the 1906 revolution. Under the new system, you only had to be a member of a seminary, or you had to be a mujtahid, but if they were short of mujtahids, they in fact employed members of the seminaries who were students and who would be mujtahids.
Could you please explain to the tribunal what a mujtahid is?
Mujtahid is a jurisprudent, a person well versed with the Sharia laws and who can judge and who can solve problems and explain legal matters to the Ummah.
So the mujtahids or students of the seminary had the authority to impose the death sentence based on these vague categories such as muharib and the other categories that you've mentioned. Is that correct?
That is correct. But the difference being mujtahid's judgment was final and could not be appealed unless he himself accepted that he made a mistake. But the member of the seminary, which is talabe, who's not a mujtahid, but he's done some studies in the Sharia law, he could be corrected by a mujtahid at a higher level or at the same level.
And how would you describe the relationship between the Islamic revolutionary courts and the other branches of governments, including the supreme leader? Would you characterize those courts as independent or impartial of the other branches of government, including the supreme leader?
I wouldn't, no, I don't. And I have my reasons for it. I have mentioned it in my statement. Because they're liable to dismissal at any time. It's not, they are not appointed for life. Even the Chief Justice or the head of the judiciary is only appointed for 5 years by the guide or the Wali Amr or Wali Faqih, the supreme jurisprudent. And in fact, they're very much at the mercy of the higher authorities and at their orders.
Thank you.
In practice, this has been shown on all occasions, more or less, even to date.
I'm sorry. Thank you. Before turning to the final sets of questions I have, I want to just return briefly to one other aspect of Sharia law, which is at paragraphs 32 to 36 of your statement, and that's relating to the criminal responsibility of children under the Sharia law. Could you explain to the tribunal what rules applied with respect to the execution of minors, those under 18 years of age? What was the age at which individuals could be sentenced to death under the Sharia laws?
Well, according, under the Sharia law, which is repeated in the law of Islamic punishment, and it's not a, it's the codified version of the Sharia, which is practiced in the country and is subject to revision every 5 years or more. The responsibility begins at the age of puberty, at the Sharia age of puberty. For girls, it's 9 lunar years, which is 8 years and a few months. And for boys, it's 15 lunar years, meaning 14 years and a few months.
So it's correct to say that under the Sharia laws, as interpreted by the Supreme Leader, girls as young as 8 years of age and boys as young as 14 years of age could be sentenced to death?
Yes.
Thank you. Now, I would like to take you, finally, to the question of the rights of defendants appearing before the Islamic revolutionary courts. At paragraph 49 of your statement, you refer to a statement by the Prosecutor General at that time of Iran. This is a statement which was published in Eطلاعات newspaper on 9 March 1982. The statement is attributed to Mr. Rabbani Amlashi, I believe, if I pronounced that correctly. And this is what he says about the role of defense counsel. Their attorneys may defend the prisoners provided that at least they have belief in the guilt of these groups as Muharrib and El-Hadi, which means atheist, and would be ready to base their defense on the grade of their crime, demanding clemency and lenient punishments. They should not declare that the terrorist, the agent, the Muharrib and the Mufsid are innocent and demand their return to the society, enabling them to repeat their crimes. Would it be fair to say that the Prosecutor General in effect is saying that a defense counsel may only plead on behalf of his or her client to mitigate punishment but not to prove innocence?
That is correct.
Thank you. And finally, Dr. Matin Daftari, I would like to turn to paragraph 53 of your statement, where you speak about the treatment of defense counsel, in particular at subparagraph C of paragraph 53, where you refer to the mistreatment of defense counsel. You say the following, and I'm just going to read briefly, and we can, I think, conclude after that, Mr. President. You explained that in December 1981, the International Commission of Jurists recorded that a newly qualified lawyer, Mohsen Jahandar, had been condemned and executed by firing squad in August 1981 for having defended persons on trial in revolutionary tribunals. On 1st November 1981, another young lawyer, Mohammad Reza Khaksar Bakhtiari, who defended political prisoners, members of the Mujahideen, was executed solely for having undertaken the defense of the enemies of the regime. Other members of the bar executed in this period included Manouchehr Masoudi, the former legal advisor to President Bani Sadr, Zia Modarres, a prominent lawyer and former assistant disciplinary prosecutor of the bar, Dr. Mahbub Majzoub, Mehdi Amin Amin, a veteran lawyer of prominence, former legal advisor of Iran National Airlines and a leader in the Baha'i faith, and Dr. Manouchehr Qa'im Maqami, also of the Baha'i faith. So would it be fair to say that being a defense counsel in the Islamic Republic was a hazardous occupation.
I didn't get your last sentence.
Would it be fair to say that those that defended their clients before the revolutionary courts would expose themselves to significant risk of arrest, torture, and even execution?
I definitely think so, because I only know of 3 lawyers who tried to defend, which I've mentioned in the statement. And the situation was such, harassment in such a manner that lawyers did not dare to get near the tribunals, and those being tried, going through brief trials and summary trials and not having any contacts with the outside, they had no chance whatsoever, neither themselves nor their family, to contact lawyers and ask them to defend them. So, I mean, there was a sort of atmosphere of, in fact, harassment, that no one did anything at all. And this is what they best wanted. They wanted best for what they were doing at the time. Because under their concepts, although Rabbani Amlashi and his other colleagues have always mentioned that under the Sharia law, vekalat, or the presence of counsels and lawyers are permitted. What they actually, in fact, mean is ordinary power of attorney for doing errands for you. And as far as they were concerned, they did not need trained members of the bar. They thought any person who takes a vekalat to do something on behalf of someone, I mean, this is how they actually define the concept of attorneyship, and not what we understand as the right of defense and the duties of a attorney at law, and the person who is there to actually exercise the right of defense in favor of people who are being tried in the courts of law.
Thank you, Dr. Matin Daftari. Mr. President, in keeping to the schedule, that completes my questioning. I leave it to the court.
A number of the members have questions. If you would deal with them now, I think it would be more convenient. Professor Mutwa, well, let's start at the far end.
Yes,
Professor Mutwa. And then
yes, thank you. I'll be very quick. 2 weeks ago, I addressed the International Bar Association. There were 5,000 members in Dublin. I'm concerned about the independence of the Iranian bar, which had a very high reputation. The question is, did you ever get any support from the International Bar Association? Has this issue been raised by the International Bar Association to provide solidarity?
Well, very little support at the time when actually the bar was at the point of being completely suppressed by this regime in Iran. Because the regime thought that by the suppression of the bar, they would open the way for the type of justice that they wanted to establish and to practice. And the right of defense should disappear so that the one-man justice of a judge being both prosecutor and counsel for defense, as well as juge d'instruction, would act. I'll tell you something which I experienced myself at the time. I was in Europe, and my colleague, the other vice president of the Bar Council, who was appointed by the bar to represent the Iranian bar at the organization you mentioned, exactly. He was informed after the bar was taken over by the Iranian regime and the newly qualified lawyer was put in charge of it. He was informed that he has paid your membership fees, and you cannot come to our meetings anymore.
Professor.
Thank you very much, Mr. Matin Daftari. Much of your testimony has centered on jurisprudence, on the interpretation of Islamic law. And I just want to hear from you, if you could state clearly for the tribunal and clarify a number of issues. One, is it your view that Sharia law is not compatible with justice, or not compatible with the idea of human rights? Do you take the view that the concepts of Munafiqin, for example, or Mufsid, ours, those who are corrupt on earth, or even the concept of Muharib, those who are at war with God, do you take the view that those are corruptions of Islamic law by the Republic of Iran?
Those are what?
Corruptions of Islamic law. Or do you take the view that that Islamic law is really illegitimate and incompatible with human rights and justice, and that it should be replaced with secular law in Iran? I think it's important for you to clarify this for the tribunal so that we are clear about whether the disagreement that you have with the Republic is one of Sharia law, period, or the Republic's interpretation of Sharia law.
Well, I take the view that what has been imposed on Iran and what is practiced in Iran as Islamic law is incompatible with justice and human rights.
Do you take the view, though, that there is a version of Sharia law that could be compatible with justice and human rights?
Well, since I'm not a Sharia lawyer, and since I have only had access to what was presented to me by this regime, all I know about the Sharia law is what they have presented in various documents and in the form of the law of Islamic punishment to us. And that is incompatible with modern justice. It's a clash between an ancient school and the results of modern development in human rights and the results of the age of enlightenment, which we enjoy at the moment in the form of human rights and Universal Declaration of Human Rights and other concepts which are around it.
Let me just press Mr. President one more time. Is there a place, any country in the world where you could imagine legitimate Sharia law being practiced?
I do not know.
Thank you.
Thank you for your testimony. I have two briefly interrelated questions. You have given evidence concerning the age of criminal responsibility of children. And in terms of girls, you've stated it's near the age of 9, a little bit under, and for boys it would be near the age of 15. Well, according to those legal precepts, does that mean that girls under the age of 9 or boys under the age of 15 cannot be jailed because they cannot be criminally responsible for their acts?
That's correct. In the clear concept, yes, it is correct.
And then my second question is that if those boys or girls under the age of criminal responsibility were unrecognized religious minorities, would that be an exception to the criminal responsibility, or are they also protected as children, even though they might be unrecognized religious minorities?
Well, I must elaborate that matters such as these are silent in the law. They have not written anything about it. It's been under the Article 167, I believe, it's the Principle 167, I believe, of the Constitution. The Sharia judges are given the full power of implementing whatever they think is the law and not what is written in the codes. Therefore, I mean, much of the matters which are to be dealt with in this society and much of the matters which are dealt with, for example, things like hypocrisy or things like atheism or a few other concepts which are also punished and punished under the Sharia law, they don't have a place in the actual the Islamic law, the law of Islamic punishment. The law of Islamic punishment has only codified certain parts of the law which can be practiced by the actual mujtahids in the courts, and they are directed to refer to existing documents, existing sources by various other jurisprudence, various other faqihs. As far as the children are concerned also, which you have mentioned, may I just add that Iran has become, has actually ratified the Convention on the Rights of Children, on the rights of the child, with many exceptions. And that means they have gone so far, as I have mentioned in my document also, in more details, in so far as that, more or less, it's as though they have not ratified it. And this has been protested by the committee concerning the convention, and coming into terms in some manner. And what is practiced right now, if a child at the age of 16 or 17 murders anyone, he's condemned to death, but he's not executed until he attains the age of 18. And he's kept until the age of 18 in prison. Then, on his birthday, he's liable to be executed, and we've had many cases.
Thank you very much, sir. Thank you for the trouble you've gone to prepare your statement and your evidence for us. We are indebted to you. You are excused. I think we will stand adjourned until
Mr. President,
2 o'clock.
I apologize. Would it be possible for me to direct two very short questions to Dr. Matin Daftari?
I should have asked you. It's my fault, not yours. Please go ahead.
Thank you, Mr. President, for your indulgence. Very quickly, Mr. Matin Daftari, we have several statements in the Commission's report, to which my colleague, Mr. Cooper, alluded, where children under the age of 8 and 14, respectively, were in prison with their parents. To the extent that it is true that children could not be sentenced to prison, would it be accurate to say that many of them were in effect imprisoned by virtue of the imprisonment of their parents?
Well, they were not considered as prisoners. They were considered as people who have to stay with their mothers, I think.
Thank you. And finally, would it be correct to say that in your statement, you have not appeared as an expert on Sharia law in order to determine whether Sharia law could potentially be reinterpreted in some other light, but that you have restricted your statement to statements of fact as to how Sharia law was in effect interpreted and applied by the Islamic Republic of Iran during the years that are relevant to this tribunal. Would that be a correct understanding of your statement?
That is correct.
Thank you, Mr.
Could
President.
I just put that question slightly differently? As I understood you, sir, you were not trying to interpret Sharia law at all. You were telling us what was said to be Sharia law in Iran nowadays.
Yes, what's practiced in Iran nowadays.
As practiced.
As
Whether
practiced.
that is Sharia law or not, you expressed no opinion.
Yes.
Thank you. We stand adjourned until 2 o'clock.
Thank you.
Everyone rise. Please wait until the judges leave.